Sorry. I want to talk about the best interest of the child because you've mentioned that many times, and I know when you and I have talked, you've mentioned that many times, that that's been a high priority for all of us, and that you have committed to making that a very important part and the keystone to what you're doing in this legislation.
Absolutely.
So there's only 2 references in the legislation that have references to the best interests of the child. The first one is in legislative intent, which has no legal effect. It pronounces that placement decisions will be governed by the child's best interest. Is that correct?
That's right.
And then the second one, the only other provision here, is in section 45.009, which says that the department is not prohibited from exercising its duty as the child's managing conservator to make decisions in the child's best interest. Is that correct?
That's correct.
So this provision does not apply to the child welfare providers with whom the state contracts, who remain free to put their religious beliefs first. Is that correct?
I missed that. I'm sorry.
It does not apply to the child welfare providers with whom the state contracts, who remain free to put their religious beliefs first. Is that correct?
So to put their beliefs first, to
in
not
front
violate
of the best interest of the child.
To not violate their interest, yes. I say to put their interest first.
They're the provider's interest first.
I don't agree with the assertion that, again, that you're putting the provider's interest. The providers are ready to serve any child. I'm not aware of any provider that is going to refuse any child of any type.
I would
anywhere.
hope that's true, Representative Frank, but you know, unfortunately, that's what the concern that a lot of us have is this only permits rather than requires a best interest standard.
The best interest standard, and I mentioned it in the layout, but the best interest standard is something that was not in the bill initially, and it was not in the bill because, frankly, it didn't need to be because it's already in statute. It's not something that was being changed, okay? So it's something that is going to supersede regardless. We added this kind of as an abundance of caution both to the intent and into the bill, again, just to, for I got to stop saying belts and suspenders, but just for...
Is there any requirement that an agency notify DFPS when they turn someone away?
There is not. There is going to be on an amendment. There will be a referral.
Is there a requirement?
And there is not a requirement to notify.
There's no requirement that they notify DFPS when they do that.
There is no requirement to notify DFPS. There is a requirement, or there will be a requirement based on the referral language.
Is there any requirement in the bill or in the proposed amendment that they refer a child for services that they refuse?
No, there's not. I can't contemplate that happening, but.
Is there any requirement that a foster family at least report that a child has asked for services that they refuse to provide?
I'm sorry, will you repeat that?
Is there any requirement that a foster family at least report that a child has asked for services that they refuse to provide?
There is not, although it wouldn't, I was going to make a foster care reporting joke. There's a report for everything in foster homes.
And with good reason, right? These are children, vulnerable children under our care, so there's good reason for that.
In some cases, although I would tell you, when you spend more time filling out forms than you spend with the child, I would say no. The necessity of reports
I understand you have more experience with that. But Representative Frank.
Yes.
Forms are onerous. It's time-consuming to do that. I doubt that they're so onerous, though, that you can't spend time with the child, and it is extremely important, would you not say, that we have the information we need to know that these children are being best served and are not being further hurt in some way or prevented from expressing whatever their particular beliefs are because of the placement that has occurred.
It is important, but I would tell you the forms and the continued reporting is a major problem. When our CPS workers are spending 23% of their time with kids, and when foster parents are getting bogged down in the amount of forms, I would say, yes, it is a problem. It's not just let's do it for the safety of the child. If I'm filling out forms or a CPS person is stuck in their office, that is a child safety issue.
Final couple of questions here, and then I'll stop. I just want you to tell me if these situations would be something that you envision could occur.
For the what?
Agency could occur with
Could
this
occur.
legislation.
Thank you.
That the agency could refuse to care for children who don't share their faith or turn away prospective adoptive or foster families. Would that be a possibility of something that could happen?
I don't know if that would be an impossibility. I'm not aware of any religious organization that would turn down a child for any reason, including belief. I'm not aware of one. Could there theoretically be one? Yes,
So-
I'm not aware of any.
Okay, so you're saying that no matter what the child's religious faith tradition is, no matter what the child's situation is in terms of their reproductive health care desires and needs, that they would not be turned away?
Look, from a turned away standpoint, the way it works, CPS is going to be the one that makes that decision. They should
Okay.
place the child in the home that is in the best interest. If you're telling me, do I think, well, I don't want to get into specifics. CPS is the one, the state, who is not protected, is the one who should be making that call. The more homes we have of all types, the better that they can place the child.
Could a counselor refuse to provide family reunification services to a parent who doesn't go to church or who is divorced? Would that be a possible scenario under this
Again,
legislation?
I don't
Could
believe so.
Could a counselor make that decision that is, in their opinion, not in the best interest of the child?
I don't see that, but
Could an employee of a private agency place a child with a stranger instead of a relative because the relative is gay or transgender?
again, the placement decisions are made by CPS and are not a part of this bill. CPS or the SSC are not covered. The placement decisions out of CPS are not a part of this bill.
Thank you for answering my questions and for your work on this.
Thank you,
I
ma'am.
truly want to see something here that doesn't create so much concern and fear among so many
Well,
people here. And I want to make sure that we recognize that there are a wide variety of beliefs and non-beliefs in this state, and that all should have an equal protection under what goes on here and should not be denied services because of their beliefs or because of their gender identity or any of those other factors. And I'm very concerned about it.
And I fully agree with you. I hope you heard me at the start when I bragged on folks that are participating. But I also want to say that those groups are not getting targeted with litigation by people, frankly, who are not in the business of taking care of children.
Well, I can't really speak to that except to say that I think that people, if there's litigation going on, it's because there's a perceived, if not real, sense of discrimination going on, and that's what the legal system is there to protect. And I'll defer to the next person.
Thank you very much.